Good morning or good afternoon again, and welcome to our webinar today. I'm Judy Germano, an adjunct professor of law at NYU School of Law and a co-director of the NYU Center for Cybersecurity and the chair of Women Leaders in Cybersecurity, celebrating our 10 years of programming on critical cybersecurity, AI, and technology issues. I am incredibly excited today on our talk that's coming up as part of our Deepfake Defense Initiative, and we'll be discussing deepfakes protecting your personal brand in the AI age. There's a lot of evidence and information out there that deepfakes are no longer a hypothetical threat. It's something we've been talking about at NYU Center for Cybersecurity for some years now, but with the prevalence of AI tools becoming better and more readily available, the threats are significant and increasing. And it's become increasingly difficult to understand what is real and what is fake, and the barrage of information that's being used for fraud and exploitation and deception is incredibly concerning. There are a lot of harms. And when we talk about protecting your personal brand, it's thought of, or I think of it quite broadly, as each of us as individuals and our brand, as well as organizationally, because it can impact obviously government and organizations, as well as everyday citizens, celebrities, and others. The thought is, what do we do, and what protections, or the question is, what protections do we have with the synthetic media becoming more and more realistic? And understanding there are laws out there. As a former federal prosecutor and someone who focuses on cybercrime cases and investigations and teaching, we do look to traditional laws that can help address questions of fraud, sexual exploitation, and deception. But we remain asking the question again and again, are the laws enough? Are there new and creative ways that we can think about protecting ourselves, our brands, our organizations, and our institutions, including, for example, with intellectual property and trademark laws? And understanding also, how do we help see that law enforcement and others who can help protect us through civil or criminal investigations have access to the potential ways that we can look at the deepfake problem with potential solutions in law, in contracts, in relationships. So today we'll explore three central questions. How far can intellectual property and related legal protections go in protecting our personal and professional brands? How are lawmakers, regulators, courts, platforms, and companies responding to the growing risk of deepfake fraud and abuse? And also, what can individuals and organizations do to better authenticate identity, respond to impersonation, and preserve trust? I am incredibly excited to welcome to you today three powerhouse women experts on this topic. If they can please join me on screen here. We have Professor Jean Fromer of NYU School of Law, a leading intellectual property scholar and vice dean of university partnerships at NYU Law. Welcome, Jeannie. We have Lisa Boykin, Director of Business and Legal Affairs for Netflix. Lisa is an NYU Law alum and a member of the NYU Law Board of Trustees, and will bring to this conversation a highly valuable corporate and entertainment sector perspective. Thank you, Lisa. Welcome. And we have Jennifer Wu, who also is an NYU Law alum and also a member of the NYU Law Board of Trustees. Jennifer is founding partner of Groombridge, Wu, Bonham, and Stone. She has been recognized as a top IP law litigator and provides terrific experience as from the private sector law firm side. So thank all three of you, or I thank all three of you for joining us today. We are getting, this program has been approved to offer CLE credit, as noted in the program materials. At some point shortly into the program, a mysterious point, I guess, it will occur that Mariana Kozak, who helped organize today's event, will join us with the secret and then not so secret CLE code that you should put in your materials to get credit for your time with us. So again, thank you. I'm going to start with you, Jeannie. When someone creates a realistic digital replica of another person's face, voice, or mannerisms, what legal rights are potentially implicated, and what are the most significant gaps as you see from your perspective?
Yeah, thanks for that question. So let me just lay the groundwork because when people talk about intellectual property, there are often a bunch of different rights that might be underneath it. And I'd say the three most relevant rights here are potentially trademark, copyright, and right of publicity. And so for those of you who don't do intellectual property, I think the way to think about trademarks is those are what we think about when we think about brands and logos, Coca-Cola, Apple. But trademarks are broader than that. Trademarks can be any symbol, a word, an image. They could be a smell, a sound, a shape that is distinctive of source. It stands for a source and it's used in commerce, and we could talk more about that. But the idea is that anything capable of carrying meaning and being used to signify source can be a trademark. And so that is one potential avenue here. And I'll talk about some of the limitations, but let me throw out some of the other things too. Copyright is what we tend to think about when we think about art. So by art, I mean it could be paintings, it could be songs, it could be books, movies. And so copyright is what governs that space, and copyright protects original works of authorship that are fixed in a tangible medium of expression, to be very specific about it. And so that's a potential avenue, but it also has some limitations. And the third avenue is right of publicity. And right of publicity is, and I should say the trademark is, it's federal law, but there are also state laws. Copyright is principally federal law, and right of publicity at this point is state by state laws, and that creates some vulnerabilities too. Right of publicity is about an ownership of one's identity being used commercially. And this could be the ownership of your name, your likeness, your voice, your signature, your persona, but aspects of your identity. There also are other protections potentially, and we could talk about some of them, but those I think are the principal ones. And if you're a lawyer looking at this, these weren't laws that were created for deepfakes. These weren't laws that were created, at this for this moment in time. And so these are things, as we'll discuss, that people are trying to use today to provide protection in these spaces, but they're not for that because brands don't sound like deep fakes or digital images or digital music and copyright doesn't feel like it's about that either when we're thinking about songs. And when we think about someone's picture being used in an ad, it's a little bit closer. But one of the issues there is that it's state by state. And so depending on your jurisdiction, you're going to get different protection. And so I'm glad to go into some of the limitations, but none of them is going to be a great fit. And so there are going to be holes in existing legal protection. So my bottom line is try to invoke them, but you're not going to have ironclad protection.
Thank you. And just to back up for a moment, when we talk about deep fakes, we consider that as synthetic media or usually AI enabled productions that can be of a photo, a video, or an audio file to make it appear as something real when in fact it is not. And a
Mhm.
deep fake can be wholly fabricated or it can be manipulated video, audio, or photo files to make it change a little bit, maybe add a fifth participant into our webinar. But interestingly, you mentioned trademark includes smell, and that got me thinking about what's ahead as we consider neurotechnology and where we may go. We'll have to consider, but hopefully not soon or too soon, adding or amending our deepfake understanding as to how far it can go. But back to the point of these laws, trademark, copyright, right of publicity, did not necessarily or did not they were not created to contemplate deep fake challenges. We see that very much in the criminal side as well, and in civil enforcement actions that the laws are adopting and emerging. So Jeannie, just to stick with you for a moment in terms of the gaps, because a trademark, you think of a brand as something that exists in a holistic way, but deepfakes can be manipulated and changed. Are these areas of law broad enough to protect us?
Well, that's the part of the problem. I mean, trademark is not a great fit because, first of all, trademarks require use in commerce. And so they're great at protecting business transactions. They require something to be designating source, meaning that something stands for, a representation that it represents a company, so that when I'm buying Coca-Cola, that I think it's coming from a particular source. And it requires a likelihood of confusion relating to commerce. And so, to the extent we think about, let's say, a scenario where someone, um, let's say, makes a synthetic AI created image of a celebrity, a non-celebrity, and passes that off, it may be harder to say that's about a use in commerce per se. There may be scenarios where that happens, but I think broadly speaking, I think that's going to be harder because it's less likely that it's designating a source in the sense we think about businesses, and that it's likely to confuse consumers. It may be likely to confuse people, but it may not be likely to confuse consumers in the way we think about trademarks. And that's why trademark is such a tough fit. And it's funny because, we in the title of this, you talk about personal brands. And we've had this shift in our culture where I think everyone goes about talking about their individual brands. And as a scholar in this space, we've had the shift too, where scholars have wondered, well, trademark maybe should have this shift as well, because we are all standing in for ourselves and our brand. And to the point where maybe there should be self marks in some ways, because Kim Kardashian represents herself every time she's out there. Right. And we all do every time we post on Instagram or we're representing ourselves. So we are living in a different age, but trademark law in some ways hasn't caught up to that fully. Copyright is for works of authorship, and personal identity in some ways slips through the cracks. It's hard to, think about people being a work of authorship, even though people author works. And so even if, you're creating, someone's voice or someone's likeness, and copyright might do some work here, it's hard for it to do comprehensive work of protecting someone's identity writ large. And so that's the worry about copyright. And the worry I alluded to about right of publicity, first of all, similar to trademark, it's often limited to the commercial use of identity, and it's not going to help as much in with some of the most dignitary harms that are non-commercial. And also, it's going to vary state by state. And the last thing I'll say is, because it is state-based, the copyright laws that are federal can end up preempting it.
Excellent
So these
point.
are all piecemeal. They all can do some work. They're not comprehensively there.
I think it's time for a change then. And I think you make a great point about self marks and understanding how individual and corporate brands are being used online and in this information age in which we now live, which has we've experienced this in some of the other legal areas of understanding how traditional laws are applied in cybercrime by comparison. But we are seeing deepfakes used to take a personality, a celebrity, for example, and commit fraud and sell products that they are not actually endorsing. And so that could deceive a consumer. It could be identity, it could be if there is a self mark being recognized, it could be a use of that. But maybe it's good old fashioned fraud that addresses the issue, which not good old fashioned, but bad, but good laws that protect against. traditional fraud that we have applied to cybercrime. But Jennifer, Lisa, if you have thoughts on this issue in terms of the gaps and what an individual might be able to do with regard to protecting under traditional IP law, or is it time to change the law?
I'm happy to go. As a patent lawyer, I tend to think that civil litigation comes with the burden of proving harm. So almost every one of the types of remedies that you've mentioned, whether it's trademark or right of publicity or state consumer protection law, requires proof of harm, which almost puts the onus on the plaintiff to say that my celebrity is so much that my brand is damaged. And I think the question that you're asking is like, what can individuals do? Just say, like, if you are a young associate starting a law firm, or you're a marketing rep and you don't have the kind of Kim Kardashian brand, and someone makes a deep fake of you that's circulating saying something that is untoward or maybe something not that you would say, how do you prove harm? And I agree with Jeannie that the laws are not great at protecting private individuals because of the onus becomes a trial on like, how were you harmed? Like, what was the value of your brand to begin with? The fact that you said something different, well, could you have said that? Maybe you just changed your mind. Maybe you don't eat Cheerios and you like Wheaties now, right? So I think that when I looked at this issue, I actually don't think that deepfakes are revolutionizing the law, right? Like the idea that people have impersonated other people has been around since the Shakespearean times. Like the whole point of Shakespeare is putting on a mask and impersonating someone else. Like we have Julius Caesar, we have lots of examples in history of people impersonating other people. What's changed is the availability of one, accessibility of impersonation online. So that's one aspect. And then secondly, it's really the idea that the impersonation kind of is uncontrollable because the person who creates the AI, kind of deep fake may not have the intent of harming. They might say, make me a few funny videos with famous celebrities saying something silly. And most of the criminal impersonation statutes that I've looked at, and I looked at these in advance of this panel, including New York, require an intent to obtain a benefit or injure or defraud another. And so someone who's sort of just saying like, AI, make me some funny videos and then just post the lot, how can I prove intent? But if we start with kind of the historical context for like, you called it fraud, Judy, but I think it's really impersonation. What we allow impersonation when it's like, kind of Jimmy Kimmel, Jimmy Fallon impersonating a celebrity because that's for humor. That's free speech. That's one kind of end of the spectrum. Then there's another end where people are impersonating for intent to defraud or to do something untoward. And in the middle sits this kind of AI deep fake where you're not sure which one it is. So if you're sitting there and you're a private individual and you see a deep fake of yourself circulating, you actually don't have information to basically go to the district attorney and say there's intent to defraud unless you've been defrauded. Someone's actually used your image or likeness to do a face ID and get your money from a bank, right? So if you don't have evidence intent, then you got to prove harm. And that also requires investment of time and energy. So if your brand isn't big enough, you won't go do that. So in my view, I think the statutes for criminal liability could be written to be broader, to not require as much intent, but just to criminalize impersonation, right, where it's not for a legitimate purpose, right? Like if it's for a First Amendment, we don't want to cross that line. But in general, impersonation undermines the legitimacy of both the government, but also officials, but also people in society. Like the fact that we don't know whether certain congressional people are alive or not alive because we think there's deepfake AI photos circulating is not good for society. And whatever statutes we have for private individuals to sue, whether it's trademark, right of publicity, right of privacy, state consumer protection laws, they don't account for the harm to society of not knowing that even like this video that you're looking at, is this Jen or is this a deep fake of Jen that AI has, put up there? And so, there's an aspect of this that I think is really important, which is the technology is sort of like, making us distrust each other. And so I think that there should be sort of federal or kind of broader kind of uniform action on this to acknowledge that context. With respect to individuals, I think the private causes of action, the people like who can bring a lawsuit, whether with a contingent lawyer like or someone else by hiring a private lawyer like me on an hourly basis, that's going to be the type of individual who has a lot of money sunk into their brand, a very important influencer or celebrity, or like a brand that's, kind of can spend money, but probably won't be accessible to what Professor Sam S. Stryker used to call the Cadillac rickshaw model of law, which is if you are rich, you can afford a Cadillac, and if you're, indigent, you can afford a rickshaw. But in between, regardless of the private causes of actions that you might bring, you may not be able to afford, or no contingent people are able to take on your case if you don't have enough harm. So that's my perspective from like a real world perspective. And coming from the patent world, I think the idea of impersonation has been out there for a really long time, right? People in technology have been impersonating people within companies, within all the tech companies for a very long time. I think what's changed is that there's people are more aware of it. And I do think some aspects of it are criminalized for good reason, right? Like some aspects are for like, kind of for porn or for things that we really think impersonating a public official, right? Those types of impersonations have been criminalized. But I do think that it would be useful to examine broader categories of that to say that we don't condone this kind of behavior. But what if it doesn't come from someone within the United States? Like, how do we criminalize that? And how do we enforce that? So these are all big questions I think we have to grapple with. But my like personal answer is if I see impersonation of me, I kind of laugh at it. It's sort of like, Erling Haaland from the World Cup. He's like, the memes are hilarious, right? It's a compliment to get imitation. And sort of like harm is a little bit of how you take it. And if you're not somebody, if you give it a lot of kind of voice, it will have a lot of voice. But most people who look at something that doesn't look like you probably are not going to think it's you.
Lots of great points in there. I think on the impersonation has been around for a long time. I would take it back earlier to maybe the 5th century BCE with Sun Tzu in The Art of War, where he said all warfare is based on deception. So this is in fact not a new thing, but it's so pervasive and so persuasive. So it is an important topic. But I do think also to your comments, understanding where should we draw the line and how should we think about this from a criminal versus civil liability, and really focusing on the harm as opposed to the technology itself. So the harm of how it's used, and to ensure that we don't risk being overbroad and over criminalizing something that should just be satire or funny, but also really great comments in terms of the cost, right? So somebody who can afford to protect their brand, but when we talk about deepfakes, there are so many children victims and domestic violence victims and others where deepfakes are being used to destroy reputations, harass, sexual exploitation, and understanding what kind of laws we need for remedies that are right size, that don't over criminalize or over punish First Amendment rights and exercise, but also protect each of our own reputations, brands, and freedoms in that way. But Lisa, I'd like to turn to you in terms of, from your expertise in the corporate and entertainment sector, how has generative AI changed the nature and the scale of identity misuse? How is it coming up for you in your role and in your industry? And what are the risks that companies are most concerned about today in the entertainment sector?
Well, good morning, everyone. I first just wanted to give a little context about sort of what I do and how this issue plays out for me at work. So I'm a lawyer on the film team at Netflix, and I negotiate the talent deals with our actors, writers, and directors, and the Netflix films. And so this issue around AI and our ability to use someone's image, came up most recently in the SAG-AFTRA strike the year before last, and it's something that, talent is very concerned about what they're actually giving consent to when they agree to be in a feature film or a television show. So just wanted to provide that context for how it comes up from my perspective. So historically, the misuse of an actor's identity typically involved an unauthorized photograph, a commercial endorsement, or the use of a person's name or likeness. But of course, today, AI can recreate not just someone's appearance, but their voice, facial expressions, mannerisms, and even the essence of their performance. And that shifts the conversation from protecting a person's image to protecting their identity. And so from the entertainment perspective, one of the biggest changes is that identity has become a negotiable asset. In talent deals today, we're no longer talking about only the name and likeness rights. We're negotiating provisions around digital replicas, AI-generated performances, voice rights, biometric scans. future uses of performance captured, consent, compensation, approval rights, reuse. And many of these issues, of course, as I mentioned, came to the forefront during the SAG-AFTRA strike a few years ago, and they've really fundamentally changed how talent agreements are drafted. And so the risks that companies are most concerned about, go well beyond copyright infringement. They're concerned about unauthorized use of a performer's digital replica, deepfakes that falsely depict an actor saying or doing something that they never did, changes to their performance. Of course, as we talked about, fraud involving AI-generated voices, authorizing payments, business transactions, things like that. Misuse of their biometric data, reputational harm that sadly can spread globally in a matter of hours before we can even have a legal response to it. I think that what emerged from the SAG-AFTRA strike in terms of how it impacted how we do deals going forward is that now you have to get consent, very specific consent, tailored around how exactly you're going to use a person's image, their voice, in not just their performance in a film or a TV show, but with respect to any ancillary commercial endorsements. And then the questions that emerge are, how long is that consent good for? Is that, you could use it for in perpetuity in ways that the actor didn't contemplate at the time they gave consent? How are they going to be compensated for that? So these are all the things that come up in the entertainment context in terms of how we're utilizing the digital replicas of actors and using those performances down the line. I was thinking of another example also too. You can use digital replicas to, say, for example, get an audience shot and then use and pay those actors, once, but then use it forever without proper payment. These were the things that, actors were concerned about and which were, addressed. Consent is really transparency and how you're using their images. There's some ways in which the technology has really allowed us to, for example, clean up audio or clean up video in post without having to call an actor back to do that performance again. But of course, they don't want the ability of that technology then to impact their compensation. So these are things that are very clearly addressed and negotiated in the performer agreements to make sure that the protection is there for the use of their performance, while also balancing sort of the ability to be innovative on and create technologies that enhance, filmmaking for the viewer's experience.
Yeah, if I could just jump in for a second, because I think, something that Lisa just said resonated and connects very much with something Jennifer said as well. It's so apparent that, the actors and the folks in the entertainment industry are so concerned rightly about their dignity interests, their integrity interests, and they're carefully negotiating for them in the places where they have the leverage to do that. And there's so many other spaces where they themselves don't have that leverage, where they're at the mercy of third parties. And then there are all these other people that don't have that leverage anywhere because they lack the resources. And I think, thinking about this broader conversation about how we want to navigate this has to think about everyone. But I think, the experience of the entertainment industry really underscores how deeply people care.
No, that definitely is true. And I think the point that we've been making that, if you're a big celebrity and, as you mentioned, you have all the leverage to negotiate these things in great detail in your performer agreement. But what if you're a background performer or somebody without that stature or with the resources to go after unauthorized uses? There are certain celebrities who have whole teams dedicated to sort of, keeping an eye out for different unauthorized uses and making sure that they go after those platforms or services, studios, et cetera, that may have used their image without their consent. But, for those who don't have those resources, that I think that's why this particular issue was so amplified during the strike.
Mhm.
Uh, Jeannie, you mentioned back to the point about self-marks, and we have seen some celebrities seeking trademark protection for certain phrases, voices, gestures, or images. You did already touch upon the limits, but do you think to this point that we're recognizing how deep this issue is, both for celebrities and non-celebrities? Is there a way, could this be setting the bar or creating a new standard that others could follow? Is it even going to work to have trademark protection for certain limited bits of us or our brand that we might be able to then expand on to make our point?
Yeah, so Judy, I think what you're referring to is what we've seen in recent months is a number of celebrities have been applying for trademark registrations on for sound marks. So I said it's not as typical. Usually, when we think about trademarks, we think about words, maybe images, occasionally smells. I'm thinking about things like Play-Doh, which have a very distinct smell. But they've been applying for sound marks. So Matthew McConaughey filed earlier in 2026 to register his vocal likeness and catchphrases. Lionel Richie filed to register "Hello, is it me you're looking for?" and "Say You Say Me," him singing those choruses. Taylor Swift filed for her saying "Hey, it's Taylor Swift" and "Hey, it's Taylor." And so that's not even her singing her most notable lyrics, but actually thinking there may be someone making a replica of her and they would introduce themselves. And so here she is protecting her voice and protecting her introduction of herself with her name. And so I think, we're going to see if one, they're going to be able to get that because it already is. I think, people are standing on not the sturdiest ground when they're trying to seek trademark protection for themselves because trademark law has been resistant to that. I will also say that scholars, a colleague of mine, Jennifer Rothman at University of Pennsylvania, has done wonderful work excavating that the origins of trademark law actually really support these personality-based rights. If we look at the origins of trademark law, it's actually about protecting artisans' personality rights. So, and if you look before, the Industrial Revolution takes off, when businesses are actually about individuals, trademarks are actually mixed up with individuals. It's actually when the corporate form takes off that trademarks become something very different. And so what these artists are trying to do is actually in some ways harken back to this pre-industrial time that now as we're living in this post-industrial perhaps time it is perhaps call it back to there, but they are standing on shaky ground given where trademark law has gone, where they're saying this is for entertainment services and they're saying this is for myself. And trademark law has a hard time with that. So we're going to see if they could get it through. They're well resourced, and I'm guessing they're willing to fight the fight. So we'll see what the trademark office does with that. And we'll also see how broadly courts and others are going to allow them to enforce these rights. It's going to be harder for others who are not in the business, so to speak, to be able to do things like this, and people without the resources that they have to file for rights. Now, I will say you don't have to have trademark registration to have trademark protection. Trademark law is provides protection as long as you're using your mark in commerce. So if Taylor Swift, and I will say Taylor Swift has been, I say this to my copyright law students, Taylor Swift's been a copyright badass because she's really pushed the boundaries there to do really interesting things in terms of protecting her dignitary interests there. And maybe we could say she's becoming a trademark badass now in this space. But if, they're going to succeed in doing this, maybe they are setting precedent for folks who might not have the resources to register their trademarks and then can rely on using their mark in commerce and having protection as a common law matter So they may be able to get protection, get out there, and then help people that are less resourced. But people will have to understand and know about this. And typically, it's the more sophisticated that know that they can use these rights to do things. That's part of the problem.
Yeah,
And the sophisticated people who join our webinars. Thank you all for
Exactly.
being with
Show
us
up to the
today.
webinars. Yes.
yeah, and I think that like traditional trademark law does account for it, but as Jeannie says, it's kind of a blunt tool to address it. So like for example, there are old cases on this. I mean, people might remember there was like a case that was brought by on behalf of Rosa Parks' estate against the hip hop duo Outkast, Parks v. LaFace Records. That was in 2003, which I know is the dark ages. But the song's chorus, they felt was disrespectful to her. It said, "Aha, hush that fuss. Everyone move to the back of the bus. Do you want to bump and slump with us? Be the type of people make the club get crunk." And there was a debate over whether her like name and really her likeness was being used improperly. So I think in terms of artistic expression, this is where I think it's factual, and where it's hard to prove trademark kind of violation is really likelihood of actual confusion. Like, do we actually think right, that like what was being said there was something that like she was saying, or is this outcast interpretation of what Rosa Parks was saying? And some would say that maybe this is like, a compliment to her that this popular song was being, kind of used. So, I think ultimately the district court judge upheld Outcast's right to use her name in that case, and that was back again like 1999. And then it was appealed, where I think at some point it eventually, settled. But I think that these are case by case determinations, and it's hard to show actual confusion because you're based on a survey. And I think that the jury's still out on what surveys will show that's really usable as evidence, and whether you have recruited. I have, for example, tried to recruit people for surveys in patent cases, and I had one case that was about real-time traffic, and the other side conducted a survey to show that real-time traffic, because they were the patentee, was really important to people. And they had a series of questions. The first question was like, if you were late to work, would you use real-time traffic to get there sooner to show the value? And I think like 80% said yes. Then it was like, if your mom was dying, would you use real-time traffic to get to the hospital? But only like 30% said they would use real-time traffic. So like that's not what we thought was going to be said, right? You would assume that, your mother, you would use real-time traffic, maybe not your job. So it makes you wonder, like, well, you're paying the survey people, who you surveyed, were they paying attention? Were they clicking C for every survey question? So I think anytime you have a survey from a practical perspective and as a litigator, I think you have to assume that it's subject to attack, and then you got to get experts to interpret the survey. And again, the costs just, rise exponentially once you need to have that level of proof. So if we really want to put teeth around these kinds of claims, it's got to be like justice has to be more accessible to people rather than everything being at least a couple $1 million lawsuit.
And Lisa, you talked about the importance, in terms of building in protection through contracts and the work that you do in the negotiations. Do the terms of contracts effectively protect against some of these concerns that we've been discussing? And are they citing specific laws, whether in trademark or otherwise? Or is there more to develop in the area of contract law as well?
So where I'm seeing this issue in actor agreements, and again, referencing that recent SAG-AFTRA strike where the details around the use of digital replicas and everything, that's a very hot button topic. And now in actor agreements, we have a specific form that if there's any anticipated use of taking a digital replica of an actor, that you have to include in their agreement this form that details the limitations of the use of the replica, their representations that you make about how you're going to safely store the digital replica. And of course, they have to consent to that use each and every time. So those are the ways that we're seeing this issue play out in performer agreements.
And those are with hopefully party, that's usually in the sense of parties trying to come to agreement, follow the laws. But when we talk about some of these false endorsements or fraudulent use of celebrities or other individuals' images, I think it gets maybe harder. And how much, to your points, Jeannie and Jennifer, that you made about recourse based on consumer confusion or false endorsements, how hard is it to support that in a case?
I mean, I think there's some old cases where people try to say you use the likeness. I think what you run into is kind of like consumer confusion or not, right? Like if someone is endorsing something that they haven't, again, you're just getting into proof for evidence, which is why I tend to think that like it's a blunt tool, that it depends on the facts, and that criminal liability, like if you wanted to kind of, and it can be civil, but like from a state level, just say businesses are entitled not to have deep fakes destroy their business. Like that's a better tool from a statutory perspective, writing legislation, than trying to say each individual has to like establish this consumer confusion, right? The law is basically very protective of First Amendment rights and your ability to kind of exercise artistic expression and speech. And so every time you're kind of like challenging it and saying, hey, you owe me money because you've harmed me, it really is, it just depends on how it becomes just a money play. Like how much money is this worth? If your brand's worth a lot, then it's worth a lot. But if you're just starting out, it doesn't seem like it's worth investing those resources. And that leads to a proliferation of deepfakes that remain ignored until you bring a lawsuit and then everyone goes and looks at it. Right. Like, I mean, what goes viral is if you make a big deal out of it. So this might just be like a PR management issue. But if I had a client come to me and say, look, I'm a celebrity that doesn't do endorsements, and someone says I've endorsed Wheaties, I would say, like, how much do you care about this? Because once we file a lawsuit, everyone's going to care. It's going to hit the legal press. Everyone's going to know, and everyone's going to go look at it. So what's the goal here? Like what does justice mean to you? And I think that just saying that we should get rid of deepfakes isn't the solution. Like the law can't give you justice, but it might be able to give you peace. So how do we navigate to a place where you can move on and like live your life? And what's the thing that's bothering you? Is it that everyone's looking at it, or no one's looking at it, or just exists in either? And this is just really unfair, and so we should do something about it. Is it based on principle? And most clients I have ultimately don't stand on principle because the money's coming out of their pocketbook, right? So it's a little bit of that kind of dynamic that's going on, of like, what's it really worth to you? So I don't really think you can talk about deep fakes and kind of the causes of action without discussing the relative amount of money that the harm has created, just because of this dynamic here.
And I think what you're saying, like when celebrities see that their image is being used, that they'll just post something, on social media saying, hey, that wasn't me, because just as you pointed out, the cost for going after somebody for, saying that you endorsed a product or something like that, it's just so expensive that most of this just goes unchallenged.
Yeah, I will say that, I mean, there's a lot of evidence that shows that disclaimers do end up doing a lot of work here. And that could be a cheaper pathway to go down. I think a lot about, we've been talking a lot about dignitary harms, and Jennifer referred in the beginning to trust. And I think one of the biggest epidemics we're facing in society right now is not knowing what, we've never faced more information, and we've never known less what we can trust than we do now. And the deepfake problem is as much a systematic problem about that. And I think we're also going to have to think long and hard about how we confront that. And one piece of this might be about disclosing how things are made and where they're coming from. And that might give us more information to go on about what we might trust.
And there's in light of this discussion, one of the audience members is asking about, a lot of the focus has been on artistic protections and celebrities, but how about the rest of us? And recognizing the point I made earlier about deepfakes impacting everyday citizens in personal lives, as well as professional brands, reputations. Journalists have been impacted. They've been used for suppressing political dissidents. I think that you've all made great points about how sometimes the better resource celebrity actions might raise the issue to a level that gives it more attention. But then how do we apply those to everyday individuals? And if you have thoughts on that in terms of how some of these conversations or the cases that it could be applied, whether for legislative changes or litigation or just building awareness. Thoughts on that?
So I tend to think that people who create deep fakes for like bad motives have put their motives online, right? There was a kind of infamous example of mother in Pennsylvania who created deep fakes of her daughter's cheerleading rivals, like drinking and depicting them in sort of like situations that were not good. And that was charged as harassment, but it's because there was like motive. And so part of like what wins cases and litigations, whether it's deep fakes or something else, is don't tell me why you win under the law, but why you should win. And so I think in examining deep fakes, it's important to look at motive. If someone is making a deep fake as a joke and just like for fun, that's one thing. But if you really want to make a good deep fake that someone will believe, there might be motive to tear down your rival, right? Like if you want a celebrity to endorse Nike versus Adidas or something else, right? So typically, even when we bring litigation, we're always looking for the backstory of like, why are we here? Like, why is it worth the jury's time to sit here or the judge's time to sit here and listen to us? And so even though the facts and the evidence might lead you to a legal conclusion, as a litigator, I tend to start with the facts of like, why are we here versus what's the law? And the reason that that makes sense if you're a trial lawyer is the jury doesn't get the law or the jury form or even like the instructions on the law until after the facts have been presented. So it's like if you've ever been a juror, right, you sit there and you listen to all these facts. You don't know what you're being asked to decide. You don't even know what the charge is. You don't know that it's harassment. You don't know that it's right of publicity. You don't know what it is. And at the end, the judge might jail certain issues, like get rid of certain issues before they even get to the jury. And then they give you the jury verdict form. And then the judge does like a reading of every piece of law all at once without giving you like a binder of the law. So I think when we think about resolution to these cases, it's not whether you can bring a claim, it's how do you win the claim? And the way you win a claim is by telling a compelling narrative that someone was out to get you. And this is the tool that they use to get you is by using a deep fake. So I would start with the narrative. If you've been in two companies are in competition, one creates a deep fake of the celebrity endorser endorsing their fishing rod versus the other one. There's motive there. And all of a sudden you have a case because then you can tell these facts. And then regardless of what the law says, the jury is at some level going to find a way to get to the right result. So I would start with, is your client a good person? Were they harmed by someone who's a bad person? Do the facts support that there's a claim here? In which case, find a litigator. And if you have good facts, you will end up with a claim. We might need more legislation anyway, but start with the individual facts of what's the motive that the other side has to create the deepfake to harm you.
A question from from an audience member for you, Lisa, is to the point that this becomes an evolving or significantly growing concern. Do you anticipate organizations having AI governance and content security teams in the entertainment sector? I mean, we've seen those types of teams developing in for certain platforms as well as some other organizations, but do you think that's a trend that we might expect more of?
I think that would be a very expensive proposition, right? If you were imagining, say, a legacy studio or a streamer monitoring deepfakes across all platforms for every celebrity that's ever been in any of their content. Of course, there's monitoring for infringement. I don't know that there would be monitoring necessarily for the sort of broad deep fake for individuals. So I don't know that the trend's going to go in that direction. Could be wrong, but it just seems like that would be a massive undertaking. I think, definitely if there are certain things that go viral and come to light that are problematic and entertainment companies are certainly on the lookout for things like that as they are looking for infringement and issuing takedown notices and all the sorts of things that come with sort of your traditional copyright infringement. But I would guess that it happens so fast, and it's the problem is just so massive that I don't know sort of what entities could monitor this in any sort of way and how would you, with the things that could be bordering on First Amendment protected free speech, parody, all that? Would they capture those things or something, just the things that seem more egregious? I mean, it would really be a very big undertaking.
I guess one of the harms of AI enabled technology is that it can cause manipulated images and false information at great scale. But a benefit is that it can also help uh, find infringements perhaps at a greater scale, faster, and processing a lot more information than in the past. So I do wonder, since you mentioned that there is monitoring for infringement, if there are ways to do that possibly more broadly. And one of the things I think when we consider deepfakes is the importance of flipping this problem on its head and not just weeding out the bad stuff, because I think there's so much of it. It's a losing battle, and the technology is so good, it's hard to discern what's a deepfake versus not. And maybe in flipping the problem on its head, we need to worry about or focus on authenticating content. So maybe as we talk about, protecting our brand against infringements and deception, and brand as individuals or otherwise,
Mm-hmm.
perhaps we could really focus instead, and is the better balance, on strengthening the veracity of who we actually are with authenticated content and authenticated branding. What do you all think of that approach?
I like Jeannie's idea of everybody having their sort of individual watermark or something that authenticates who they are when they're giving endorsements or posting content or whatever, something that's uniquely identified to them so that audiences can trust the veracity of what they're seeing. So, maybe that's something a trend towards something like that is the wave of the future.
Yeah, I like that too. I mean, we currently, right, like for payments, have secure servers with way of authentication, right? It should be relatively simple to implement that when something pops up on your screen, there's like a trust website security certificate that authenticates it's real. We've had experience with this before. Certainly, like personal data is always authenticated. I think that people have not invested the money in it because it's unclear like what the harm was, what the value is. So, but that doesn't infringe free speech rights to say like I pay for a check mark that this is a authorized, and you have a third party provider that goes through and authenticates that the image or likeness is that person and not a deep fake. So long as they're not being, sort of used in sort of nefarious ways. So it seems like that technology didn't create this problem necessarily. Humans did, but technology can solve the technology problem to the extent that there is one.
Yeah, and I think we're experiencing this generational or technological shift where people haven't gotten used to this yet. I think that's exactly right. We, may know not to, when we see certain things, not to believe them. And this is one that I don't think we fully processed it yet, and we're too trusting. And we're learning not to trust so easily anymore, even if it looks real. And so, yeah, we need to flip the script. We need to learn not to automatically trust despite our instincts. And I think we're going to get there, but we need to rewire.
Or right, and I think this is where I've gone, which is instead because there's no way to know whether something's deep fake or not online, I just have to go to the source. Like, I was talking to Lisa right last week, and she was saying, you should watch Little House on the Prairie. So I was like, great, this is a recommendation from someone who actually has watched it. I went and watched it all week this week, and it's great, right? So I think that like some level is the antidote if you don't have a ton of money to spend on litigation for deepfakes is get out in the real world and be with people who like actually are humans, right? The part of the issue with deepfakes and AI is so far AIs haven't created like robot people yet. We'll get there, right? Like you'll see a person on the street, you don't know if it's them. We're going to get there, but for now they're limited to screens. So one of the antidotes to deepfakes, if you want to understand if something's being really endorsed, work your way up to knowing Kim Kardashian, and then you can ask her directly, right? And if you're someone like me, you would actually try to do that. And I'm sure Lisa could get there and Jeannie could too. You guys are both phenomenal networkers, right? Like it's like 3 degrees with both of you. So I think that part of the antidote to deepfakes and creating trust is screens are are where the kind of fakes exist, because then they're deep fakes. But it turns out that inhuman person interactions so far are not deep fake yet. So let's take advantage of that while we have it.
So 30 years ago, in 1996, I coordinated a conference called Cyberspace and the Law. And one of the panels was on protecting intellectual property online. Admittedly, I did not foresee deepfakes as they are termed today, but there were concerns about what do we do with protecting our information. And another panel was on protecting children online, as these issues do converge in the area of deepfakes. 3 decades later, we're still trying to solve those problems. And personally, I think a very big way, as we've touched upon today, is building awareness and making sure that people understand the significance of the threats, of how they can be used, how the technology can be used and abused, and steps that people can take to protect themselves. We just have 3 minutes left, I think, for each of you. Any takeaway comments on that and on this issue, which is clearly a necessary ongoing conversation? Jennifer, I'll start with you.
I think, I think it's just a technological tool. We should not be afraid of deepfakes. It may be a problem, but people also said, oh, when we have email, we're not going to be able to verify that it actually came from you. Right. So I am a technology forward person. So I think we should embrace technology and all that comes with it. The fact that you can make easy deepfakes, it can be a bad thing, but doesn't have to be a bad thing if you create trust and security around it. And then we're going to have to tackle the next form of it. Right. So look forward and not backwards is what I would say.
And Lisa?
I would just say that, I echo what Jennifer mentioned, which is that, this technology is revolutionizing filmmaking, and there are so many benefits to it. Obviously, this downside, that it erodes public trust and confidence. And, maybe some of the tools that we talked about here, with some way to verify identity, et cetera. Maybe that's the way to go with this. I don't know necessarily that like adding more laws at this point for some of these things is going to really tackle the problem, because the laws just can't keep up, with the technology. And by the time the harm is done, and the people who have access to pursue litigation, all those things that we mentioned earlier. So scary, but that I think there's an upside here to all of this, notwithstanding.
Okay, thank you. And Jeannie?
Yeah, I'd echo all of that. I think that technology creates problems, but it also can help solve them. I think we have to be attentive in the background to our key values and what we want to protect here. If we want to protect humanity, if we want to protect trust, if we want to protect dignity, those are things we just have to keep grounded and not let technology companies, fully drive the discourse, not let just make sure those are things that get promoted, and find the ways that we could use laws and our values to make sure that these values stay important to us, and we'll find solutions.
Okay. So earlier this year, I started the Deepfake Defense Initiative and Deepfake Security Alliance to help spread the word, discuss the issues, and look at it from an interdisciplinary perspective: law enforcement and fraud, intellectual property protections, and different industry sector impacts. This has been enlightening for me in terms of the limits and the hopes of intellectual property law on this issue, and also the importance of ongoing dialogue. And to be able to share this conversation and this content with each of you experts has been a privilege and an honor. So thank you all for joining, and thank you, audience members, for joining us for a very important conversation in our Deepfake Defense series. So hope to see you soon, and till next time, thank you.